Good morning, everyone, and welcome to today's webinar hosted by Better Business Bureau. I am Savannah Kimball, Washington Outreach Manager at your Better Business Bureau, serving Alaska, Oregon, and Western Washington. Today, we have the opportunity to hear from Chet Arceneaux, who will be presenting on how the do's and don'ts of hiring and firing will help your business. If you have questions at any time throughout the presentation, please type them in the question section and Chad will answer them at the end of the program. Thank you for joining us, and the presentation is now yours, Chad.
Thanks so much, Savannah. Good morning, and as Savannah mentioned, my name is Chet Arceneaux. I'm an attorney with Eisenhower, Carlson, which is located here in Tacoma, Washington. We are a full-service business and banking law firm, and a good bit of my practice is dedicated to helping business owners deal with employment law related issues. So one of the things that frequently comes up in any employment law practice has to do with what can you do and what can't you do in the hiring process and in the process of terminating employees. So when Savannah asked that we put on this program, I thought it was a good opportunity to educate some of the Better Business Bureau membership about those issues. So with that said, why is it important to get it right? Well, as any business owner knows, there are a myriad of laws related to human resource compliance and employment law compliance. A lot of issues that can lead to litigation and civil liability exposure for risk come up in the hiring process and in the termination process. Laws that are examples of some of the laws that are implicated are Title VII. Many of you are probably familiar with the Title VII, which is the federal law which relates to discrimination on the basis of race and national origin and some other protected classes, gender, for example. The Age Discrimination in Employment Act, or the ADEA, which protects workers who are over 40 years of age. Many folks may not realize it, but even the Fair Credit Reporting Act is implicated in the hiring process many times, and can be implicated in the disciplinary process for employees, and we'll get touch on how the Fair Credit Reporting Act might be implicated. If you're in Washington, you know that you have to contend with and comply with Washington's law against discrimination. Washington has its own anti-discrimination statute, and other states such as Alaska and Oregon may have similar state laws that must be complied with. And then, of course, you know, there are claims that can crop up for retaliatory discharge, negligent hiring, and all sorts of things that can come up in the hiring process and are implicated sometimes in termination. So we'll touch on ways to deal with that. But as indicated, there are many other statutes and regulations that employers should be mindful of. And for that reason, it's important that you educate yourself about being sure that you are getting it right. So you're interested in a particular applicant, and I suppose we should back up, because the hiring process begins even before the interview stage. As you all know, you ask folks typically to fill out an application for employment, and then once that person has filled out their application, you cull through piles of applicants, and you narrow down on a couple of folks who you think are interesting, and that then triggers an interview. But whether it's in the application or whether it's in the interview, there are some questions that can be asked that can ruin a first date. And I'm calling it a first date because we talk about the employer-employee relationship right? And many folks think of the interview as a first date, or an application as kind of the first date. You're trying on a particular employee to see whether or not that person is going to be a good fit for your organization. But during the interview process, there are guidelines as to what you can ask and what you can't ask. So, for example, and I've got a series of examples over the next couple of slides for you, but inquiries related to age. Well, you can ask a fair inquiry about a particular employee. For example, on an application might be to include their date of birth, or proof of their true age, right? But if you're asking that question in a way that implies a preference to persons under the age of 40, you're likely to run afoul of the Age Discrimination and Employment Act that we just finished talking about. Similarly, questions about citizenship. Well, it's a fair question to ask whether or not someone can lawfully be employed in this country. That's a fair question, at least under Washington law. But it is not a fair question under Washington law to ask whether or not someone is a citizen of this country, or to require that before someone's made a job offer that they provide a birth certificate or some other proof of their ability to work. Certainly, upon being given an offer to work, you can ask a prospective employee to provide proof of their ability to work in this country. But at the interview stage, if you're asking for that sort of information, you're probably running afoul of some anti-discrimination laws and state statutes. And the list goes on in terms of fair inquiries and unfair employment inquiries. And I'll tell you, for your reference, there is a list, if you're in Washington, that sets all this out, and it's under the Washington Administrative Code, and it's Washington Administrative Code section 162-12-140. So if you're sitting at your computer and you'd like to look at that section, it'll list out more extensively what types of pre-employment inquiries are fair and don't run afoul of the law, and what types of pre-employment inquiries will get you into trouble. So, for example, you can see that one of the types of inquiries that's listed has to do with photo requests. You can, I guess, imagine why it might be an unfair pre-employment inquiry to ask someone for their photo before they've ever been given an opportunity to interview for the position. We lawyers always think about things in terms of what types of claims might that give rise to. So in the employment law context, what comes to mind for me are claims of disparate treatment and claims of racial or ethnic discrimination, because a prospective employee might claim, if they are required to provide a photo before ever being asked to an interview and ever being offered a job, they might claim that the employer is using those photos to weed out people on the basis of some protected class. Maybe the employer the claim is that the employer is asked for my photo because they wanted to see whether or not I was Hispanic, Asian, a woman, so forth and so on. You can run down the list of protected classes, but for that reason, that particular type of inquiry, pre-employment that is prohibited. Now, certainly after you've interviewed someone and you've given them an offer of employment, You could ask at that point, at least under Washington law, for that the person provide a photo for identification purposes. Maybe you need a photo for them to, a photo of them for an ID badge or something like that. And at that point, you could say that the employer has at least eliminated the risk of there being some perception of unlawful discrimination. Now, I'll tell you that at least under Washington law, there is a generalized exemption, right, to what employment inquiries are considered fair and what employment inquiries might be considered unfair and potentially discriminatory. That same Washington Administrative Code section says that that RCW 4960 recognizes an exemption to unfair pre-employment inquiries when the inquiries are based upon a bona fide occupational qualification. So technically, I suppose an employer could ask just about anything that they want on during an interview or on an employment application, so long as they, at least under Washington law, so long as they can tie it to a bona fide occupational qualification. Although I have to tell you that I think that an employer would have a very difficult time relating some occupational qualification to, for example, questions about what someone's race or ethnicity is, what someone's citizenship is, what someone's sex or gender is. And so, it's important to be very careful, in the interview process to avoid the appearance of questions or inquiries that might be construed as having some discriminatory basis. With respect to arrests, there's been some interesting developments over the last couple of years in terms of EEOC guidance that has to do with the treatment of arrest information as it relates to the offers of employment. And part of the reason for the EEOC's increased interest in this area has to do with the fact that there are some statistical studies that show that arrest data, for one, is probably not a reliable indicator of criminal behavior in and of itself, and two, that there have been studies that indicate that the use of arrest information can have a disparate impact upon some protected classes. So you'll want to be careful in terms of your treatment of any arrest information that you might receive during the interview process, and my strong opinion about it is that that the treatment of that type of information should be run through legal counsel and through your human resources department. The same can be said for conviction information, and we'll talk a little bit more about arrests and convictions later on. But insofar as conviction information is concerned, the same thing has been borne out in some of the studies that the EEOC is relying on in their scrutiny of this area. And while convictions in and of themselves can show that someone did in fact engage in a particular type of behavior, because of the disparate impact that the use of conviction data has had in the pre-employment process, employers should be careful about their use of that data, and should, to the extent that it's used, should be able to relate their use of the information if it's going to be used for an adverse employment decision. In other words, it's going to be used to weed someone out from the process, right? Then the employer should be able to relate that particular conviction to something that is also associated with the core functions of the job. So for example, let's say someone had a conviction for reckless driving that is, 5, 6, 7 years old, and they're applying for a position as a receptionist. I would say that an employer would probably have a very difficult time articulating why a reckless driving conviction should bar someone from working as a receptionist. The job doesn't involve driving or anything like that, right? Now flip the script and say that you've got an employee who's applying to be a delivery driver, and they've got 3 DUIs and 4 reckless driving convictions in the last 2 years. Well, that might be something that the employer looks at and probably might be able to articulate some bona fide reasons as to why that would impact that person's ability to work in that capacity. There are a number of different laws that are implicated in the employment law context. So having the application reviewed for legal compliance is important. The next question that I think you need to be asking is whether or not your managers and your supervisors have undergone any training for best practices in interviewing potential new hires. Folks a lot of times think that an interview is just a conversation, and I suppose, like I said earlier, yeah, there is an aspect of the interview process where you're assessing whether or not someone is going to be a good fit for the organization. In fact, most people say that, if you didn't think someone was qualified for the job, you probably wouldn't have called them in to interview with you in the first place. At the interview stage, you're probably trying to figure out whether or not the person's going to be a good fit and trying to fill in some of that additional information that perhaps wasn't listed on a resume or in the application itself. But that being said, interviews can a lot of times lapse into a really conversational style, and to the extent that they do lapse into conversational style, there is a danger that an employer may inadvertently ask a question that is prohibited, or may give the impression to the employee or the potential hire that there is some discriminatory motive at work, and I would say that to the extent that the person actually gets hired, maybe that small mistake is forgotten. But to the extent that the potential employee is not hired, little things that may be to the interviewer innocent questions can prompt the not hired employee to come up with all sorts of reasons as to why that one question that was asked was the sole reason that they weren't hired, and there was some discriminatory animus. I'll give you an example. For example, you're interviewing someone, and you lots of times people want to know about folks' families. You want to know what a person is like outside of the office. So the interviewer asks, so are you married? How many kids do you have? Oh, are you planning on having any more children? For the interviewer, all of those might seem to be innocent questions. However, I will tell you that for the employee, particularly the employee who is not hired and is married and has a lot of time commitments at home and happens to have several children, and those children are pulling on that person's time, and they're planning on having more children, and maybe they were going to take maternity leave at some point. If they're not hired, all of those questions then become red flags for them, and at the end of the day, perception is reality, at least insofar as that potential hire goes. So it's important that folks are undergoing training so that they're familiar with what best practices are, what types of questions can be asked, and what types of questions should not be asked in the interview process. Now, you've completed your interview, and you decide with your staff and stuff. You go, I think I kind of like that potential hire. I think that they might actually be a good fit. And because we think they're going to be a good fit, let's do a background check on that person. I decided to insert just a brief section about background checks because in 2012, the Society for Human Resource Management reported that 69% of employers were using criminal background checks to screen applicants. And to the extent that folks are using criminal background checks, it looks like a lot of you are, criminal background checks, if they're used properly, they can be a very effective tool in the hiring process, kind of like we were talking earlier about the driver position that might be offered to someone versus a indoor receptionist position, and how that might relate to convictions for DUI or negligent driving and things of the like. So it can make a great tool for screening, for managing folks. If you've got someone who you actually have hired, and they're, to stick with the same example, they're a driver. You can make some decisions about the continuation of the employment relationship moving down the road by using background checks, and you can use some of that information to help mitigate risk, right? For drivers who continue to get arrests or convictions for bad driving behavior, maybe that's something that you want to look at in terms of disciplinary action and/or termination of the employment relationship because that person can't be trusted to drive, right? But the EEOC has let us know in recent years that to the extent that you all as employers are using people's criminal history and making employment decisions, that in some instances that use can violate the prohibition against employment discrimination under Title VII. Which is the federal law. And here in Washington, in some instances, use of that information can violate Washington's law against discrimination, RCW 4960. So again, it's important that you get it right. Just in terms of general guidelines with respect to background checks, and this is an area where I would say people, employers, companies, really do need legal guidance and HR guidance in terms of compliance, because you need to have consistent application of background checks to everyone that's applying for a particular position. I will tell you that as a general rule in the employment law world, anytime you're doing something that relates to some people and not to all people, you're probably getting yourself into trouble, or at least exposing yourself to some risk. So to the extent that you are using background checks, it needs to apply to everyone applying for a particular position. That does not mean that every position that you're offering necessarily needs to be subject to a background check. So, for example, if you've got a position that deals with highly sensitive information or consumer information, Social Security numbers, banking account information for customers, and things like that, maybe you can say that that's a position that we want to background check for. The receptionist position, well, is that person going to be having access to sensitive information, or are they just answering the phone? Are they driving a vehicle, or are they just sitting at a desk? Those are the types of considerations that you want to think about when you're determining what types of positions might implicate the need for use of a criminal background check. You'll notice that that this slide indicates that there has to be notice to the applicant or employee before a background check is performed. And there are very specific notice requirements under the Fair Credit Reporting Act that relate to the use of background checks in the employment law context. And that's why I say that it's important that you if you're doing background checks and you haven't consulted with legal counsel or with human resources who is up to speed on these types of issues, then I strongly urge you to do so, because you do not want to run afoul of the Fair Credit Reporting Act. And you'll see that it also indicates that the background check should be justified based on business necessity. That you should identify specific convictions that will result in adverse employment action, again, based on business necessity. And there are some individualized assessments that we'll talk about that you can implement to help you determine what you're going to do with the information that you get from a criminal background check. But business necessity, you'll see, is bolded, and that's because everything that you do around this topic, if you can't find a business necessity for engaging in the activity, then I would suggest that it's probably not a worthwhile activity for you to be engaging in. Probably exposes you to some risk. You've gone through your lawyers, and you've gone through the human resources, your human resource personnel, and you're sure that you're following all the guidelines for implementing these background checks, and you've got someone who comes back with an arrest. It's important to remember, in terms of your treatment of that information, that arrests are not the same as convictions. An arrest does not show that a particular crime has occurred. Now, while it might prompt you to investigate a little bit further and inquire with the employee whether or not the conduct at issue relates to the job and justifies you engaging in some adverse employment actions such as discipline or termination and things like that, that's all it should trigger is an inquiry on your part, at least at this stage, until you get more facts. An arrest should indicate to the employer, whether it's at the pre-employment stage or during employment, that need more facts. Conviction, on the other hand, is a whole different ball of wax, because a conviction, is sufficient to show that so-and-so robbed that store, so-and-so drove drunk, so-and-so assaulted somebody else last year leaving the bar, right? A conviction is sufficient to show that a person engaged in a particular type of criminal conduct. However, again, a conviction, kind of like an arrest, alone, in and of itself, I mean, barring some horrible, heinous, you axe murdered everyone type crime, a conviction in and of itself generally is not sufficient to establish that a person should be denied employment or that a person should be terminated. To go back to our example about the driver who gets convicted of DUI, well, that might be that's probably a pretty good indication that you can engage in some adverse employment action. But the receptionist who gets convicted of DUI and otherwise is doing her job, without blemish, and she's got a great performance record, that DUI conviction is probably not sufficient to show that you should be taking some type of adverse employment action against that person, or that you should deny that person employment. there is guidance on these issues. And the EEOC tells us that there's two ways that you can determine how to use this information in determining whether to hire somebody, and also in determining whether to take some adverse employment action against someone. Now, one of these ways has to do with validation under the uniform guidelines. And if you want to know where the uniform guidelines are, you can. There's a citation here that I've listed for you, and you can also take a look at the EEOC's guidance on consideration of arrest and conviction reports in employment decisions. And you can find that very easily by Googling the EEOC website, and that is the name of the EEOC guidance. The other way is through an individualized assessment, and an individualized assessment simply means that the employer has developed a targeted screen, and all of this should be documented in the employer's policies and procedures and things like that. But an individualized assessment simply means that you've developed a targeted screen that considers the nature of the crime, the time that's lapsed between when the crime was committed or when the conviction occurred, and then the nature of the job. And you'll see that we've got listed there the three green factors. Lawyers like to use names of cases, and green is a case, not a color in this instance. But there was a case that came out, and the name of the case is green, and it talks about how employers can establish business necessity and for their employment decisions around arrest and conviction data. And consideration of those three factors, the nature of the crime, the time that's lapsed, and the nature of the job itself, are make up what's called an individualized assessment. And then along with that is the opportunity for the employee or the prospective employee to be heard about the circumstances surrounding the particular incident. And only then, and only after consideration of all of that information, should the employer be making a determination as to what type of action should be taken, and whether the action is consistent with the employer's particular business necessity. Now, on to the breakup. As many relationships go, sometimes the employer-employee relationship turns bad, and in a lot of instances, it very much is like a breakup. And when folks get ready to do the breakup, and the employer is about ready to terminate the employee, what types of things should you be considering? I've advised folks who have employees come in late a number of times. There's no documentation regarding the employee coming in late, and maybe they just kind of don't for whatever reason, they don't like the person's personality, and they say, hey, can I fire so and so? And my usual response is, well, is there an employment contract? If they say no, I go, okay. Is this person a union employee? Are there some labor laws at work? And they say no. Oh, so this is an at-will employment relationship. And if the employer says yes, I say, well, yeah, you can probably fire that person, but you'd be exposing yourself to a bunch of liability. And if you get sued, well, there's a high probability that you might get sued because all of the facts and circumstances surrounding the breakup haven't been properly documented. Documenting employee performance throughout the employer-employee relationship is critical to establishing when and whether or not it's appropriate to terminate the relationship. But beyond termination, documenting employee performance is something that I encourage employers to do for a myriad of other reasons, because it allows for opportunities for the employee to grow and to develop within the organization. No one wants to be hiring and firing folks persistently. It costs money when you have to hire somebody and retrain them only to let them go and hire somebody else and retrain them. But when you're documenting your employees, what you should be doing is allowing for opportunities to identify areas of strength and weakness in that employee and areas where that person needs to grow. Documenting employee performance allows for goal setting. It lets the employee provide input to the organization about what's working, what's not working. You can determine whether to promote people, whether to demote people, and ultimately, our topic for today, whether or not termination is appropriate. As you're going about documenting employee performance, you want to be linking that performance to some policy, handbook, the employee's job description. If there are collective bargaining agreements, you want to be linking any issues that are coming up in that performance to those objective criteria. And that's because it's important to retain objectivity, and you want to be able to show objectivity if you ever have to justify your termination decision. Again, for at least for Washington is an at-will employment state. As long as there's not a employment contract, and as long as there's not some collective bargaining agreement or other agreement for continued employment, employers are generally permitted to terminate the employment relationship at any time for any reason, so long as it's not an illegal reason: race, gender, disability, someone wants to take leave, or they're a whistleblower, or things like that. But just because you can do something at any time and for any reason doesn't mean that you should go about it in an unprepared way. And to the extent that you have documented your employees' performance, you're preparing yourself for the day when, just like you can fire an employee for any time or for any reason, you can be sued by an employee at any time for any reason. And so you want a good paper trail to be able to document the decisions that you reached, why you reached those decisions, and that those decisions were objective, that they were based on facts, and that they weren't personal. They weren't personal because of race or ethnicity or disability or gender. And you'll see I've cited here Miles versus MNC Corp. Because federal courts have recognized that subjective evaluations are generally insufficient to rebut a prima facie case. In other words, once an employee has made a very basic showing of discrimination. To the extent that you're basing your decision on subjective criteria, you'll probably find yourself going all the way to trial on an employee's claim that they've been discriminated against. But if you have objectively documented things, you put yourself in a much better position. That doesn't mean that litigation won't necessarily ensue and it won't be ongoing, and that you might not find yourself in trial, but you put yourself in a much better position to be able to justify your actions. The same is true with respect to investigating allegations that might come up in the workplace that might trigger your decision to terminate an employee. So that in some instances, employers have an actual obligation to investigate. And the one area that comes to mind is in instances where there have been allegations of sexual harassment, or racial harassment, or some other form of unlawful harassment. In those instances, employers can have an obligation to actually investigate what's happened and take appropriate action to correct the situation. Well, if someone's been accused of, be it sexual harassment, racial harassment, gender harassment, doesn't matter. Um, you know, it's before you make that termination decision, um, do an investigation. Maintain to the extent possible the privacy and the confidentiality of that investigation, so that later on down the road, if you find that the allegations against that employee are justified, and you decide to terminate that employee, nothing's to stop that employee from saying, no, I was targeted because of what you name the reason. At least you'll be in a position to show that, no, we did our due diligence. This is the reason why we terminated. We don't have to be 100% right all of the time, but we at least have to be diligent and make a good faith effort, and that's what we did. For those of you who are using performance evaluation forms, I would say I've before I started representing employers. Now what I do for the most part is I represent employers in employment law dispute. I used to represent employees a lot, and I have to tell you that performance evaluations that use conclusory language are rife for plaintiffs' attorneys to pick holes in, and to say that that the employer is simply targeting someone because there's no objective data to support the allegation. And it's very easy for a plaintiff's lawyer to say that an employee has been terminated because of some trumped up reason, pretext, because of some pretextual reason, when there are nothing but subjective, conclusory allegations in employment evaluations and write-ups. So, and the most obvious example is a write-up or an evaluation that simply says John Smith is unreliable. Okay, well, what does that mean? What does that even mean, that John Smith is unreliable? John Smith is unreliable, so we're letting him go. We're going to fire him. If John Smith is a disgruntled employee and John Smith doesn't believe that he's unreliable, John Smith may very well turn around and sue you for that. That's very different than having documentation that says John Smith was late on May 1st, May 2nd. I counseled John Smith, brought him into the office, told him he can't be late anymore. He was late 10 more times on May 6th, 7th, 8th, 9th, 10th, 11th, 15 minutes late this day, 20 minutes late the next day. We're going to have to let him go. Very, very different. One other thing that you'll notice about that is that everything that I've talked about is focused on the performance itself rather than the perceived underlying cause. There are some circumstances that might require an employer to make accommodations for employees under the ADA or FMLA and things like that. That's why it's important to talk with legal counsel and talk with human resources before making decisions about how to address a performance issue. But the documentation itself should be focused on the behavior, not personality, not perceived underlying cause, just the facts. They're late on this day. They didn't turn in this report or that report, and things of that nature. So just something to keep in mind. Some issues that might impact you as you're shoring up, your cause, your reason, your rationale, and justifying it later for taking adverse employment action, include, for example, setting unattainable goals for employees. You don't want to be doing that, or inconsistency and documentation, documenting all some employees but not documenting all employees. your documentation should be consistent, and to the extent that it's not consistent, you're opening yourself up to allegations that you have targeted a particular employee. So you'll want to be mindful of that. The same thing goes with including your subjective criteria. You always want things to be objective. Inserting emotion, these are things to be shied away from. You want your documentation to be professional, respectful, and job related at all times. As I'm sure you've gathered from our talk, to the extent that you properly document your employees, you're probably going a long way to minimizing your litigation exposure and minimizing exposure during administrative processes, whether it be through the Equal Employment Opportunity Commission, local human rights commissions, the Washington State Human Rights Commission, and other types of administrative agencies that investigate and take up these types of issues. And also, as I mentioned, at least under Washington law, there's some case law that says that, to the extent that you fire someone and the employee can show that termination was pretext, and pretext means that it was that the reasons that you gave really weren't real reasons. They were you were just providing those reasons because really you had some discriminatory motive. And if the employee can show that that there's no basis in fact, or that you weren't actually motivated by the reasons that you gave for the termination, or that the reasons were insufficient to prompt the particular type of adverse employment action that you engaged in, then they're likely to be able to proceed in their claims of discrimination. And you can see how these issues touch back to some of the other things that we've talked about, documenting all employees versus only documenting some employees, or saying that someone is unreliable versus giving the actual facts that support that the person is unreliable because they've been late or because they haven't returned client phone calls or things of that nature. We've talked a bit about federal law and discrimination. In general, the things that some of the things, at least, that employers should be considering and thinking about before you decide to actually pull the trigger and terminate an employee, aside from whether or not you've properly documented that employee's performance, is what reason are you going to give for the termination if there's litigation, or if there's a dispute, or if there's an administrative charge. There might be 10 different reasons as to why you terminated someone. To the extent that you can articulate all of them, that's great, but you certainly want to be able to articulate the big ones. And you want to be sure that that whatever reason is articulated for the termination, that is consistent with your handbook policies or other policies or representations related to expectations for that employee's performance. Take a look at whether or not the rule that the employee violated is reasonable. If you've got a rule that says that an employee who's late 1 minute is going to get terminated, that's probably not a very reasonable rule. And to the extent that someone who's late 1 minute on a couple of occasions gets terminated, I'm sure they're not going to be a very happy employee beyond the fact that they were terminated. And a 1 minute rule is probably something that is impossible to consistently apply. across the board. And so that person's probably going to be able to point to other folks in the workforce and say, so-and-so's late 5 minutes, so-and-so's late 3 minutes. So, and you can see how that can create problems in terms of justifying your action. Did the employee have notice of the rule? All of my clients, I encourage all of my clients to have well-drafted employee handbooks. That's a service that we provide for our clients. It's also something that most law firms and some HR agencies provide for employers. And the reason you want to have a well-drafted handbook is so that the big picture items that the employee needs to be aware of in terms of what their expectations are out there. They're available. The employee has signed for that employee handbook, and when you've documented that employee saying, on this day you violated this section of the employee handbook because you took the company car down to Wild Waves and took your family on a little water park vacation in the company vehicle, they can't say, oh, well, I didn't know that I wasn't able to take the company car to Wild Waves. Well, yeah, you knew that because you signed here for this employee handbook, right? You want them to have notice. But also consider whether or not something less than termination is going to correct the problem. Again, it's expensive for you folks to hire folks, train them up, get them started in a job, only to have to replace them and start the process all over again. So be mindful of whether or not there might be other alternatives short of termination that can alleviate the situation, and that might be it could mean disciplinary action like a write-up of less than that's doesn't amount to termination. Maybe that looks like working with the employee to put them on some sort of flex schedule or something like that, or adjusting their hours, or changing their workstation, or what have you. In any number of things. But they should at least be considerations before you go to the extreme step of termination. And you also want to be mindful of how situations have been handled in the past, and that ties into the last consideration, not the last consideration, one of the last considerations. There's a ton of things that you should consider, but if you have employees who have engaged in similar behavior and have not been terminated and have not been written up, and you have another employee who's engaged in that behavior and you're looking at writing that person up, then I would suggest that you look strongly at the way that you are applying your policies, and be mindful of the fact that if you're applying those policies to some employees and not all employees, you're opening yourself up to risk of litigation and administrative charges for discrimination and things like that. I always like to end with a little disclaimer because there are all of these issues are fact specific. And there are a number of laws that touch on the issues that we've been talking about that we haven't discussed. So if any of these issues come up in your workplace, in your business, I encourage you to consult with legal counsel so that you can be sure that all of the different angles and aspects and considerations are covered.
Thank you so much, Chad. If anybody has any questions, you're welcome to include them in the questions tab or email me at savannah.kimball@thebbb.org. Thank you all for participating in today's webinar. This webinar has been recorded, and we'll post it and send it a link to you for your viewing. And we hope you have a great day, and feel free to contact BBB with any questions. I hope you have a great day.